Good afternoon or good morning, depending on which time zone you're in. We'll be starting the webinar in 1 minute. Webinar will begin in 30 seconds. Welcome everyone. I'd like to welcome you to this month's installment in the Subcontract Management Institute's monthly webinar series. Our subject today is the flow-down dilemma. The webinar syllabus that we're going to be running with today, we're going to talk about some definitions, and then we'll be talking about best practices and multi-step analysis. We're spending some time on commercial subcontracting procedures, and then we talk about some of the problems in our environment where the regulatory burdens are increasing, and then we'll be talking about some things that are being attempted to straighten out these problems. Our learning objectives today, you'll have a better understanding of how to determine which clauses must be flowed down. You'll be able to identify the benefits and weaknesses of government commercial subcontracting procedures. You'll be in a better position to explain the evolution of what we're calling regulation creep and the delusion of the efficiency and effectiveness of commercial items. And then finally, identify proposed changes to improve the process. For those of you that are new to our series, the Subcontract Management Institute is a nonprofit that's been established to maintain a body of knowledge for subcontracting, develop and deliver certification programs for both companies and individuals, and create some other tools that will be available for use by subcontracting professionals. The program has been looked at by Department of Defense, State Department, and others, and also has been briefed to the heads of DCMA and DCAA. SCMI has representation in Washington, D.C., Denver, Colorado, Los Angeles, Seattle, Brussels, and Tel Aviv. Our speakers today, we're very fortunate to have two outstanding speakers, Vic Avatesian, President of Avatesian and Associates. He is the CFO, Treasurer of the SCMI. He's an NCMA Fellow and past National President of NCMA. He's also a member of the NCMA Board of Advisors and a Director for the Procurement Roundtable. I also have Rob Burton with us today. He's a partner at Crowell and Mooring. He is the former Deputy Administrator of the Office of Federal Procurement Policy, an NCMA Fellow, a former member of the NCMA National Board, and is a member of the Board of Advisors. He is also a Director with the Procurement Roundtable. So, with those introductions, we're going to get into our series, and Rob, your slide.
Oh, hey, thanks, Jack. Thanks so much. I appreciate it. I want to thank Jack for getting up and running, too. He's been a great help in getting this webinar organized, and certainly do appreciate the opportunity to talk today on contract lowdowns. I mean, it's a very interesting topic in my view, and now that I'm in the private sector, I've been in the private sector here for 9 years, working at the Crowell and Mooring Law for now. And you would be surprised how many issues, legal issues, develop because of flow-downs. There's mass confusion by prime contractors as to what to flow to subcontractors, and just safe to say, a lot of problems because of the ambiguity and the lack of clarity on this whole subject results in problems, and I think that's safe to say. So I wanted to start off real basic with the definition of subcontract and subcontractor. Here's part of the problem. One of the problems is just the lack of clarity with respect to the definition of these very, very basic terms. Everybody goes to FAR Part 2, right? You go FAR Part 2 to get definitions. That whole section of FAR Part 2 is on definitions. And lo and behold, in FAR Part 2, there is no definition of subcontractor and no definition of subcontract. The definitions are actually piecemealed all throughout the FAR, depending upon where you are. The best definition of subcontract is in FAR 44.101, which is the FAR Part 44 is on subcontracting policy and procedures. So one would think there'd be something there with regard to definitions, and there is. There's a definition of subcontract, and as you can see from the slide, it really uses the definition of contract in SAR 2.1, and it's very, the bottom line is very broad, and a lot of people don't get that. It includes, but is not limited to, purchase orders, changes in mods to purchase orders, task orders. It's really anything except grants. It does not include grants. So you need to think in terms of a subcontract being very, very broadly defined by the government. And then also, likewise, the definition of subcontractor is very broad. So it includes vendors, distributors, brokers, suppliers. Almost anybody will fall into the definition of subcontractor. Now I know a lot of folks are hoping they'll never, they figure because of their status, maybe they don't have to worry about all this FAR stuff and government contract procedures. And the bottom line is, if you're a subcontractor, even though you have no prime contracts with the federal government, if you're a subcontractor, you probably got responsibilities and requirements under the Federal Acquisition Regulation, and that's what we're going to be looking at. Even if you're a commercial prime contractor, you do all your work basically with commercial company, but you happen to have a subcontractor to a prime contractor that does work with the federal government, beware. Beware, because more likely a lot of this stuff that flows down to you, even though you never think so, because, hey, you're a commercial contractor, right? You do most of your work with the commercial world. Maybe you have a very, very small percentage with respect to the federal government. But, you know, if you're sub to a prime, you probably got some issues that you have to deal with, reporting requirements and so forth. So, Jack, turn to the next slide. So this is, I call this best practices, and if you remember nothing else from this webinar, just remember, don't fall into the trap of flowing down everything. I cannot tell you how we have that will admit that, look, this stuff is just too complicated, it's too confusing, and we don't want to be in non-compliance. So just to be safe, we're going to just flow down everything. Everything we have in our prime contract with the United States government, we're going to flow down to all of our subs. No problem, right? Well, trust me, this is not a good idea. I mean, all sorts, talk about confusion. And all of a sudden, you've got subcontractors that are going, hey, wait a minute, do I really have to comply with this? Are you kidding me? I mean, who says I need to do this? Who says my understanding is that this does not apply to me. And then you say, okay, well, don't worry about that one. But you know, if it's there, it's there. If you have flowed it down to your subcontractor, the question is, are they self-deleting? Are they self-deleting because in effect they don't apply with respect to the federal government? The federal government does not really view them as applicable. But do they apply because the prime has actually imposed it on the subcontractor? There's a lot, believe me, there's a lot of confusion here, and you get into disputes with finger pointing and so forth. and they're not necessarily self-deleting. This is a different contractual relationship between the prime and the sub. It's different than the government and the prime. And so if I, the prime, have put certain clauses into my subcontract, arguably they do apply. Now, the two parties can agree, yet, don't worry about it. But that probably should be well documented. So, I mean, it's somewhat commonsensical that you don't really want to clutter your subcontract with a bunch of stuff that does not apply, and especially, and we'll get into this, if it's commercial subcontract, if it's a commercial item that we're purchasing, you really don't want to have a whole bunch of stuff in there that's simply inapplicable at the subcontract level. So in any event, go ahead, Vic.
Rob, I was just going to add that there is one impact when they do such a thing. It increases the cost of the subcontract because they have to establish procedures to comply with those flow downs. It doesn't matter if they didn't apply to them, but they're still required to have procedures to do that. So it really impacts the cost of the program or cost of the contract.
Which gets flowed out to the taxpayers in the final analysis. So, and of course, then you're not as competitive, right? You're not as competitive as your costs go up. And so this is just, I think, something folks have to be very sensitive to. I've even seen problems where the contract clause is, the flow down is listed in the table of contents, but the actual text of the clause itself is not in the subcontract. So let's say it is a required flow down. Let's say it is a required flow down, and you have a prime who sticks in the table of contents but actually doesn't put the text in the body of the subcontract. Just sloppy, right? I mean, arguably it's administrative error. Obviously, the prime did intend for it to flow down, but why create an issue? Just, I think that contractors need to get this right, and you don't want to be sloppy. In the legal world, especially, it just doesn't play well. So in any event, a word of caution there to really do your due diligence up front. Don't flow down stuff that doesn't need to be flowed down. Okay, next, Jack. And this is basically, bottom line here is that you go through a multi-step analysis when you decide whether or not to flow something down. It's not easy. So let's say that you're dealing with a non-commercial contract between the government and the prime, and then you have maybe a commercial subcontract between the prime and the sub. You look different places. You look different places with respect to what needs to be flowed down, and it gets very, very confusing. The text of the clause is really where you have to go. In the final analysis, the text of the clause is what you want to look at. And this is not really easy, right? When must clauses be flowed down? There are triggering events, dollar thresholds, the length of time of the contract. Oftentimes it's not clear. For example, which most people think, well, hey, what about a code of conduct? I mean, an ethics code of conduct, surely that's something that would be flowed down. Well, you go to that clause, which is 5203-13. Really interesting. It's on the Contra Code of Business Ethics and Conduct, and it says subcontracts. The contractor shall include the substance of this clause in subcontracts that have a value in excess of 5.5 million and a performance period of more than 120 days. So here, I can't believe how many people say to me, wow, I mean, so my subs don't really even need to have a code of conduct unless they have a subcontract in excess of 5.5 million and a performance period of more than 120 days. And the answer, yeah. That is what most people think would be a common flow down all the time, and in effect, no, it only is if you have a subcontract in excess of 5.5 million in a performance period of more than 120 days. So that I use just as an example to show you really need to go to the clause, and you don't want to say, okay, I'm going to flow down this requirement that the subcontractor have a code of conduct, ethics and conduct. It sounds like a good idea to me, and I'm just going to flow it down. But you could be flowing it down to all of your subcontractors, and if you don't have any subcontractor over 5.5 million, you're wasting your time and you're imposing a requirement upon the subcontractor that they don't need to do. Even though in your mind you may think, well, it makes sense, right? But then you got these small businesses scurrying around trying to put in a code of conduct when they don't need to. I just think that's an example of what by your common sense would tell you that's probably a clause I'm going to flow down. And in fact, you may not be. You'd have to, and you need to look at the dollar threshold. You need to look at the performance. Bottom line is you need to look at the clause and see what it tells you. Many of these clauses do tell you whether or not to flow them down. And it gets confusing, you know, with respect to commercial contracts, you know, there is a place to go with respect to mandatory flow downs with commercial contracts, and we'll be getting to that. But bottom line, this stuff is not simple, so don't guess. The triggering events, clearly every clause has different triggering events, and then how those clauses are flowed down differs as well. I mean, there are actually a few clauses that are very clear that it has to be verbatim. You know, you have to flow it down with the exact same words. But most of our clauses allow for incorporation, incorporate the substance. So, you know, the charge from the government is you must incorporate basically the substance of the clause. It does not have to be verbatim. On the other hand, why not go ahead and do it verbatim? It just makes it a lot easier. But the bottom line here, again, a lot of flexibility. The prime contractor has flexibility with respect to what they flow down. They really can change the wording they want as long as they're incorporating the substance of the clause that's being flowed down. And then, of course, a lot of times it's completely silent as to what you do with respect to the flow down. Is verbatim? Is it just the substance of it in different words? A lot of times the FAR clause is silent and doesn't give you any guidance. So you, contractor, are in a bit of a precarious situation. All the flexibility, you also don't have much in the way of guidance. Then we're concerned about mandatory clauses, right? I mean, prime contractors want to know, what do I have to flow down? But guess what? There's a whole bunch of optional clauses which are not mandatory in nature, but boy, might be a good idea to flow them down. For example, termination for convenience. As you know, the federal government has a unique power which commercial companies don't have. The federal government can terminate for convenience, and they don't need to give you, the contractor, a reason why. It's an enormous power that the government has. Well, you as a prime contractor, if you get terminated for no reason, or no good reason in your mind, but the government has that power, and you're finished. You better have something in your subcontract that allows you to terminate that subcontract really for no good reason as well. So you may want to actually try to incorporate, try to flow down that termination for convenience clause. Now this is an agreement, right? I mean, this contractor has to agree to it. You're now at a commercial level, and this is not a mandatory flow down, but until you have you have an option to flow it down. But the subcontractor may balk, and the subcontractor may not particularly care for that. But you as the prime probably have some leverage in that regard. Same thing with the changes clause. So that is a clause you definitely want to flow down, even though it's not mandatory. So some of these clauses that the federal government impose upon the prime contractor, you want to flow down to the subcontractor, even though the government may not care. The government may say, well, you work it out with your sub, we don't really care. What you'll notice is the mandatory flow downs where it says you shall as a prime contractor will flow down. They tend to be provisions that related somehow to social and economic policy, so labor law related provisions, EEO related provisions. A lot of these types of clauses the government will absolutely require the prime contractor to flow down, but non-necessary contract clauses which are arguably to benefit of the prime contractor, such as T for C, termination for convenience, change clause. These are clauses that probably the prime contractor will want to flow down to protect itself. Government's not so much interested in the prime contractors protecting itself. So let's keep that in mind, that there may be FAR clauses that you, as the prime, want to flow down, even though the government doesn't care and the government has not made it mandatory. And then in this multi-step analysis, basically the big question that you want to ask yourself at the end here is the subcontract for a commercial item? And remember, the prime contract may not be for a commercial item, but the subcontract might be for a commercial item. And in many instances, it's for a commercial item at both the prime and the sub level. But this question opens up another whole bag of regulations called commercial item regulations. And with that, why don't we move to the next slide, Jack? And so, query, you all know that FAR Part 12 covers commercial items. And the move here for the last 20 years has really been to go to commercial item contracting. Let's keep that simple. But you know how the government is. It's not that simple. And the government, quite frankly, over the last couple of decades has complicated an unbelievable degree commercial item contracting. And Vic, I know, is going to be talking about this in a second. But it's frustrating, right? Because the whole idea was to keep this simple. FAR Part 12 has some really great language in it, with respect to contractors. And let me just read if I can find this. And if you take a look at 52.244-6, this is where you're going to find the mandatory clauses that have to be flowed down to subcontractors. So if you go to 52.244-6, it will say, as prescribed in 44-403, contractors shall insert the following clauses in subcontracts for commercial items. So just that in mind. That's very basic. And the whole idea here is that primes are supposed to use, to the maximum extent practicable, commercial item in their work. So take a look at FAR 12.101. This is sort of the overarching directive that agencies shall require prime contractors and subcontractors at all tiers to incorporate to the maximum extent practicable commercial items as components of the items supplied to the agency. And the agency shall conduct market research to determine whether commercial items are available that could meet the agency's requirements. So I just wanted you to be familiar with the fact that the government encourages agencies to use commercial item contracting and encourages at every level the use of commercial items to fulfill the needs of the agency. But I don't know how well that's really gone. And then the final point here is just remember that the prime contracts between the government and the prime contractor are covered by what we call federal common law, which is just the body of federal court cases, GAO opinions, FAR regulations. It governs that relationship. Guess what? Subcontracts are basically governed by the Uniform Criminal Code. And so what's really the number one body of rules that control the relationship between the prime and the subcontractor are actually covered by the Uniform Commercial code. So that's why the flow downs are critically important, because if you don't flow the clause down to the sub, federal law is not going to control. That's the you're basically going to look to the UCC and you know, different body of rules, things like the definition of offer and acceptance and so forth. That's going to be controlled by the Uniform Commercial Code. So what gives the nexus to the federal contracting rules and regulations is the flow down clause from the prime to the sub. That's the nexus to federal law. So again, you can see why it's so critically important to have those flow downs. Vic, I'm going to ask Jack to go to the next slide and let Vic pick it up from here.
Thank you, Rob. Good morning or good afternoon. Let me just explain why this benefit of commercial subcontracting procedure is a very important area to be familiar with. The FAR 2.101 defines what is a commercial item. There is a lot of confusion about how it is interpreted. Generally, any item that is of a type customarily used by the general public and has been sold, leased, or licensed to the general public, or any items that would satisfy criteria that are modification of a type customarily available in a commercial marketplace, or minor modification of a type not customarily available to the commercial marketplace. So as you can tell, it's open for interpretation, especially when they said of a type. And anybody that is listening can interpret any way you want what it means by a type. So that hasn't been resolved, in my opinion. And that's one thing that needs to be clarified. And there is a panel that has been put together by 2016 National Defense Authorization Act called 809 panel. And this is one of the areas, commercial item of the type, is one of the areas that they are actually looking at it. So we've got to be very careful when the government requires to prove that it is a commercial item. Now, if a commercial company has selling this and they have to modify it, there could be a question, well, is that modification really applies and makes that not a commercial item? The prime contractors also have a difficulty, and that's a reason, as Rob says, they try to just go ahead and flow down everything to all subcontracts. Commercial companies are not subject to some of these flow downs. And as Rob says, content of the clause, just not the numbers, content of the clause are very important. And subcontractors, especially commercial subcontractors that are not familiar with the doing business with the government, they don't have the people that are familiar to read the FAR and the DFAR and clauses and interpret and say, well, you should not tell their management you should not accept this clause or not. Yeah, I know in one of my clients' cases, the prime contractor actually said this commercial company the whole FAR and DFAR and wanted to know before they will hire them as a subcontractor if they are in compliance with all the FAR and DFAR clauses. Okay, and they came to me and I said, that's completely out of point. You are not required. If you are required to follow any clauses, will be only the ones that are related to the commercial companies, which is based on the latest. There's about 24 clauses that could be considered mandatory, and out of those 24 clauses, really some of them could be negotiated because some of them are something that might not apply the type of the commercial item that you're providing. One other area that I'm very much familiar with it is a cost area, especially if you're using commercial companies. If they have to follow some of the requirements, the prices are going to go up. And prime contractors maybe is no longer has a competitive edge when bidding on a contract with their competitors. So the cost and the price becomes very critical because the subcontractor has to establish administrative system to comply with some of these clauses. And that's one of the reasons in my analysis why commercial companies, especially tech companies, are not really entering defense market. Jack, next one.
Oh, hey, Vic. Hey, Jack, can you go back to the slide just for a second? Hey, Vic, I wanted to highlight one citation here for our listeners, and that's FAR 52.2125E. That is a really important clause in the world of commercial subcontracting. I really want you folks, when you have a chance, to take an actual look at the text, because this is a point that I was making about, it says, hey, you look at this list, oh good, okay, this is a mandatory list of the FAR clauses that have to be included in a commercial subcontract. Well, not so fast. If you look at it, it says the contractor is not required to flow down any FAR clause other than those in paragraph E1 in a subcontract for commercial items. But then the next sentence says, unless otherwise indicated below, the extent of the flow down shall be as required by the clause. So the very first clause that is listed is one that I used as an example on Contractor Code of Business Ethics and Conduct. Bottom line is, it's there on this mandatory list of flow down clauses to a commercial subcontract, but you need to look at the clause. Just because it's listed there doesn't mean necessarily flow down. You have to go to the clause, and the clause will say the subcontract has to be in excess of $5.5 million. So just a word of caution there. And none of this is easy, is what I'm trying to say. And so even in the commercial world where it's supposed to be easy, it's not. Anyway, I just wanted to emphasize that.
That's very good, Rob. And I was going to, I'm glad you came in because I was able to go and get a listing of the mandatory flow downs for commercial items. And in my experience, there's about 18 of them. And take a look at the FAR 52.244-6C1 that was issued January of 2017. And it would list all the mandatory clauses that are 18 of them that I could count on. But again, because subcontractors don't have the capabilities that the primes have with the experts and the people like Rob to go to, they don't read these clauses, and they just take it verbatim. And they should read some of these clauses and see actually if they want to accept that, because in some cases they might be giving out some competitive information that they don't want to. So to be careful of if you're a commercial tech companies to get advice about should I really accept those clauses. But anyway, go take a look at 52.244-6 C1, and those there you can see 18 clauses that are mandatory. Next one.
This is Jack. On that issue, SCMI did do a presentation to the 809 panel a few months ago, and my part of it, I went through those C1s, and there's a typo on the slide coming up. It's actually 20 at the high point. It took me about 3.5 hours, and I've been doing this a long time, to go through all of those to figure out what was applicable and when. People just don't have time to do that. Also, if any of you out there, the 84 people that we have listening in today, have any questions, if you look at your toolbar there, you'll find a place for typing in questions that we'll come to at the end of the session. So any questions, just go ahead and type them in and we'll come back to them. And Vic, back over to you.
Okay, next one. Okay, increased regulatory burden. I covered that a little bit, that this is the biggest concern with the commercial, especially COTS commercial items, that that the commercial companies are not interested in doing business in the federal market. I just covered the clauses, the mandatory clauses necessary for the flow down for commercial item, and I mentioned about Section 52-244-6. The numbers have increased from 4 in somewhere in year 2000 or to about 24 clauses, some mandatory and some not mandatory, in last 8 to 10 years. And for example, a very interesting clause that actually was caused by a executive order. It's the clause related then don't text while driving program. And now prime contractors are responsible to make sure that that clause is adhered to. But how do they manage second or third tier subcontractor to make sure that their employees do not text when they are driving? These are the type of clauses that are creating a significant oversight issue and cost issue for the prime contractor and for the first tier subcontractor to manage or monitor their subcontractors, second or third suppliers that are commercial company. So be aware that the burden that it's going to be causing, if you're a prime contractor and you're bidding on a competitive contract, you want to reduce the amount of burden you're putting on your subcontractor, because it's going to increase their cost, which in turn increases your cost, so you're not going to be as competitive. And similarly, for you to attract the best commercial contractors or commercial item contractors to get advantage on your competitors, that you're using the high quality or best quality or best technology for the whatever program that you're working on, that when it comes to competition and where they're doing source selection, that you will have a legs up because of using a best commercial items and the highest quality and the latest technology compared to your competitors. So to attract commercial companies, tech companies to join you as a subcontractor, you need to be concerned how you're going to get them. If you're going to push flow downs to them, you're going to lose them. They're not going to stay with you. I made a recent presentation to 809 panel. They have a team put together for called the roadblocks for commercial tech companies to join the defense market. And I explained to them all the roadblocks that one of my clients has faced over the last 2 years. They're trying to get into the commercial, into the defense market. Next one. These are some information that I thought will kind of highlight why this has become a major issue. Since 2009, that's a number of increases in clauses for commercial item. 109 of 114 apply to contractor, not just DOD. The reason I'm highlighting this, 114 clauses, additional clauses, have been implemented since 2009. That is an increased cost, and that's the area that is missing link. That anytime the government adds a clause, there is a cost related to that for the government contractor to comply and make sure they're complying. They have to write policy, procedures, they know how to comply with it and how control that. What happened? Go back. Okay. So you want to be very careful of that, what's happening. On 452 to 44.6, flow down clauses increase, as I mentioned earlier, to 24 from the 4. Now, you, as a businessman, anytime you see that kind of an increase, you know that its cost is going to have an impact on you. The interesting part on this analysis, that's the reason I put in there, is to do with 50% of the flow down are because of executive orders. And as Rob mentioned, some of these are mandatory. The reason is it has to do with the labor policies or social policies. And one of them I explained was that do not text while driving, which is a right thing to do. I mean, but again, you have to monitor and make sure you comply with it. Now, if a commercial company is selling it in a commercial market or contracting with another commercial company to provide them that their goods and services, they don't have to follow. They don't have to have any clauses flow down to them. So the price that is sold in a commercial marketplace is going to be much lower than it is selling it to the federal government. And that's the issue that 809 panel is also is looking at it, that if they can eliminate some of those burdens, that means there's going to be a cost saving to the taxpayers. And that's an important subject, I think, that 809 panel is addressing. How you can reduce cost. It's easy to increase costs by just putting more clauses or requirements and on a burden to the contractor. Taxpayers paying for it. So what if you can streamline? That's why this 809 panel was created to streamline the defense acquisition regulations, FAR and DFARS.
Well,
Go ahead.
Yeah. Vic, I was just going to say, I think you've hit upon the elephant in the room, so to speak. I think with respect to acquisition reform, there's no question that the Section 9 panel and the Trump administration has to really focus on making commercial item procurement easier than it currently is. And one way to do that is reduce the inordinate number of flow-down clauses now imposed upon commercial subcontractors. I think this is critical, and I'm somewhat optimistic that the Trump administration has focused on reducing regulatory burden as one of their principal goals. And it does appear that this new Office of American Innovation that was set up at the White House, I think acquisition reform is within the scope of what they're looking at. And I think it's just really important for everyone in the community just to be harping on the theme of simplifying commercial item procurement. So to your point, Vic, to attract some of these commercial contractors to the federal space, because they're going the other direction right now. And a lot of these, and let's be honest, a lot of these requirements did come in during the Obama administration when we're focused on all of these labor law related executive orders that imposed contracting burden on both prime contractors and subcontractors. And even to your example that you gave, Vic, regarding the texting while driving, I mean, this is not done in the commercial world, this type of micromanagement. And so I think that this whole area is very ripe for acquisition reform, as you pointed out.
It is. And Rob, I learned from you a long time ago that the mandatory flow downs really should be ones that are specifically required in the prime to include in the subcontractor. And the next one is equal opportunity employment clauses.
Right.
Yeah. So, I mean, these other ones that have come across, I mean, they're just increased cost, increased time and effort by the management. And also it opens the door for non-compliance. So every time you have all these clauses, it's easy for somebody to come and says, well, show me that you complied with this clause. Doesn't matter if it impacted what you're producing, what you're providing. They can easily say, yeah, but you're not complying. So you didn't show me that you trained your people that they should not text and drive or whatever.
Right. Yeah.
Let's go to the next one.
Vic, this is I was going to pick up here. I think this is news. This is good news. I mean, you've got Congress, maybe a little ahead of the 809 panel here, where Congress is basically in this year, in the 2018 NDAA, they are talking about commercial item contract reform, right? And it says, the Secretary of Defense shall revise the DFAR to eliminate all regulations promulgated after the date of FASA in 1994 that require a specific contract clause for a contract using commercial item acquisition procedures under FAR Part 12, except for regulations required by law or that the Secretary determines are vital to national security. Now, I am defining, of course, I don't know that we have a definition with respect to what it means, except for regulations required by law. I think that is pretty clear that that would be statutory. Do not view executive orders as falling into that category, and I doubt Congress does either. And so I think what we're saying there is, unless it's required by statute, unless Congress requires it, don't flow it in, don't use it in any commercial item acquisitions. Now, unfortunately, this is limited right now just to the Department of Defense and DFAR, and as you pointed out, Vic, a lot of these flow-down clauses apply government-wide. They're not limited to DoD contracts. So this is a great step in the right direction, but this has got to be made government-wide. And oftentimes, some of these provisions do start out in the NDA as as DoD only, but then it's broadened out before it's actually finalized. It's broadened out to government-wide. A lot of people think that it's just, the NDA just applies to the Department of Defense, but a lot of acquisition reform provisions in what is called Title 8 of NDAA have government-wide application. So I'm hoping that this one will actually have government-wide application, which could be a really great step in the right direction. And correspondingly, Jack, going to the next slide, there's another provision within the same section, 855, that specifically calls out commercial off-the-shelf subcontracts, COTS subcontracts, and it says the Secretary of Defense shall revise the DFAR to eliminate all requirements for a prime contractor to include a specific contract clause in a COTS subcontract, unless inclusion of the clause is required by law or is necessary for the contractor to the requirements of the prime contract. Again, too bad they have some of this wording here right at the end because it's not well defined, but I think the idea is correct. Let's simplify. If the COTS subcontract, we're buying a COTS item through a subcontract, for crying out loud, let's limit any type of clauses to those that are really required by statute. And of course, I think some of those required by statute need to be reconsidered, but this is a step in the right direction. So again, this goes to my theme that acquisition reform, I think, is really going to take on some of this, and I think it's absolutely critical, and we do it at this point in time. All right, Vic.
Yeah, one thing I was going to bring up, which we didn't really answer, and maybe, Rob, you can help on that. What if a mandatory clause is not flowed down by the prime? Let me just read you a couple of points that I came up with. In a breach of U.S. prime contract, if you don't do that, can be subject to numerous remedies, such as withholding of payment, termination of contract, and suspension or debarment. Rob, do you agree?
A lot of there's something called the Christian doctrine, which will actually read in a clause that has been left out. And so the Christian doctrine applies to, and then of course you get into some subjectivity, clauses that are of social or economic importance, from a public policy standpoint, and we could probably debate that. But if it is of great significance, if the government views it of great significance, for example, the termination for convenience, if the government left that out, it would probably be read into the contract through the Christian doctrine, which is basically just a doctrine that says, if you forgot it, you left it out, and it's of great social or economic importance to the government, it can be read in. So the government does have a way of curing mandatory clauses that are left out.
Okay, now we can go on Q&A.
Okay, I'm glad the Christian doctrine came up because that was one of the questions that was involved. Once upon a time, I was taught it doesn't apply to subcontracts because they're commercial, but I know there are some court cases that would send you the other way. One question has come in from one of our participants. Just for clarification, when subcontracting for a commercial item, will we still review all of the flow downs from the prime federal contract and then review the flow downs in 52244-6C1 to see which of those is applicable as well? Who wants to take that one?
Rob?
You're going to have to, unfortunately, this goes back to why this stuff is so complicated. You're going to have to look at the prime contract clauses, right? You have to actually look at those prime contract clauses and actually see what contract clause says. That's why the list is somewhat misleading. You really need to go to the clauses, and the clauses have to be flowed down will indicate, they will indicate whether or not they need to be flowed down. It's just a laborious process, and I don't know any good way to do it other than going through each of the each of the prime contract clauses. I remember I had a client that said they want to have a list. They want to have a list exactly what has to be flowed down. And I said, well, the problem is virtually every one of these clauses have, some up over the simplified acquisition threshold. If they're below the simplified acquisition threshold, they don't apply. It gets really, really confusing.
I think what I would add, something that I learned a long time ago, is that read the contract. And that's one thing that really people tend not to. You need to read all the clauses. What is in the prime contract? What is the type of product or services that is being acquired? Okay, and what are the one that applies word by word. If you don't read the contract and you don't read the clauses itself, you are not going to be able to properly determine if you want to accept that clause or it's something that you can negotiate with the prime contractor, or there's a modification to the language that you will accept, negotiate with them.
And you take a look at all of these, if you take a look at the questioner's citation 52244-6 C1, the contractor shall insert the following clauses in subcontracts for commercial items, and you get this laundry list. Right. Look how many of them have notation afterwards that says, if flow down is required in accordance with paragraph C of the clause, each one, so many of these say if it is required in accordance with the clause. For example, sick leave, you got to go to the clause and see when does it apply.
Yeah, Rob, that's why it took me 3.5 hours to go through all those, because you had to go to each individual clause. Another question, because we're getting a little short on time. Is there an appendix in the FAR that identifies all mandatory FAR flowdowns for subcontractors?
So quick answer, no. Quick answer, no. And what we've been dealing with right here is as close as you get with respect to subcontracts for commercial items. And as you probably, everybody's probably picked up from this conversation, that list is not it's not great either, because it's all specific, and you have to look at each clause and see whether it applies to your contract. So many of these things are determined by the dollar threshold of the contract and the period of performance of the contract. And so the answer is going to vary every time with respect to your individual circumstances. That's why the FAR Council has they can't give you such an easy list, because it doesn't always apply. So mandatory is not necessarily mandatory, if you know what I mean.
One area that I wanted to also bring up, especially for commercial tech companies, this is very critical, that causes them to stay away from government contracts or a subcontract, is technical right data. There are clauses in the FAR and DFAR, especially in the DFAR, that requires that the government gets a right to the tech data that is created in a as a result of a contract. Where in tech companies in the commercial market, that's their technology, then they don't want to give that right away. So for commercial companies entering to a subcontract, they want to make sure they're not losing that requirement that it's their technology and they don't want to be able to, it doesn't belong to the prime or the government. So that's another concern that commercial companies are having in dealing with the federal marketplace.
Yeah, we had one other person with a question about the 809 panel. They're not familiar with it, and could one of you give a very brief explanation of who they are and what they're doing?
Well, 809 panel, as I said, was created by FY 2016 National Defense Authorization Act, and was then Department of Defense established that panel, nominated people for that panel, and actually a former OFPP administrator, Deidre Lee, is a chairperson, and majority of the people that are in that panel are experts in the FARs and DFARs, and they both work for the government and industry. And the panel really basically, I think I wrote it down here. Let me read it. Was appointed by DOD in 2016 to review acquisition regulation and recommend streamlining and improve the efficiency and effectiveness of the process.
It's just focused on DOD, right, Vic? It's just looking at the
only DOD. Yeah, it was appointed by DOD, and what they are doing, and as I said, I talked to, I made a presentation to them 2 or 3 times, and actually today they're having a meeting on a protest, and I sent some information on that to them. What they're doing, they put a team together to look at the various things, and the way they are going to approach this is, if there is a rules, regulation, policy, they want to get opinions from the public, which rules and regulation needs to be changed to allow, and I'm talking about in a commercial area because that's my area that I'm concentrating, needs to be changed to attract more commercial tech companies to provide services and products to Department of Defense. New innovations, new things like that. That's not happening, and that's the purpose of it. And now, it's more in what I mentioned was commercial item area, but it's across the board.
Right.
And one area that it didn't say in my reading it is that that will also reduce the cost to the taxpayers. So really, it's if you go on Section 809 panel online, they have actually put all their meetings and what they're doing. They had an interim report that was issued about 3 months ago or 2.5 months ago. You can read that, and their final report was due end of next year, but it's been extended to early 2018.
2019.
Thank you, Vic.
2019, I'm sorry.
Yeah, that's the problem. It's so far away in the future. It's and I think some of these reforms we need to get moving on well before the report is issued. And then, of course, the government takes 6 months to take a look at the report. It's just a very long process. And I think some of the reforms in the commercial item subcontract area really the government can move out very swiftly well before the Section 09 recommendations are submitted. Yeah, that's our hope.
Okay.
All right,
Thank
Jack.
you very much. Thank you, Jack.
Rob and Vic, thank you very much for some great information. There was another question that had to do with getting a copy of the slides. SCMI needs to decide where they're going to put them on their website. They're not up there yet, but that will be discussed probably tomorrow. Again, thanks, Rob. Thanks, Vic. Next month, we'll continue our series with getting your subcontracts paid. That'll be on September 11th. Noon Eastern, and as in the past, there is no charge for these webinars this year.
Jack,
go ahead,
I want to mention if they have any additional question, either they can send it to you or to Rob or myself. It's on the screen now, or contact information. And thank you very much for everybody, and have a nice week.
Hey, thanks, Jack.
Thank you. And once the webinar, as soon as I terminate it, you should get a message about filling out a questionnaire. to critique the presentation today, and we would appreciate it if you would go ahead and fill that out before you completely sign out. But you should get a message asking you to do that. Thank you again, and this completes our webinar for August.